Dispensation from canonical form, CIC, Canon 1127, paragraph 2 and CCEO, Canon 835 deal with dispensation from canonical form. According to CIC, if there are grave difficulties in the way of observing the canonical form, the local ordinary can give dispensation from it. CCEO does not permit the local hierarch to give dispensation, only the apostolic see or patriarch or major archbishop can grant it, and that too only for a most grace reason. If dispensation from canonical form is obtained, some public form of celebration is to be observed. For example, the form of marriage followed by other Christian churches or denominations, or the form of marriage before a marriage registrar or civil authority is to be observed. The particular law for the Latin Catholics in India as given by CBCI and CCBI in 1988 is the following. Dispensation from the canonical form of marriage is given only in cases of mixed marriages, and that too for grave reason. In such cases, some public form of celebration should always be prescribed. Care should be taken, if such public celebration involves participation in the religious ceremonies of non-Catholics and especially non-Christians, that the principles regarding communicatio in sacri be kept in mind. The effect of not observing the prescribed marriage form is the nullity of the marriage. This also occurs when the assisting priest does not possess the necessary faculty either by virtue of office or delegation. However, if the assisting priest lacked the necessary faculty and blessed the marriage, then, in order to protect the faithful against the consequences of a lack of faculty of blessing the marriage, the Church supplies it. But only in circumstance of common error and doubt, the Church supplies the faculty. Thus, in common error of fact or of law and in positive and probable doubt of law or of fact, the Church supplies executive power of governance both for the external and the internal forum as per CIC, Canon 144 and CCEO, Canon 994. Common error presumes that the persons subject to a power have an erroneous opinion of whether a particular individual or priest has been granted this power. It can be an error of law related in some way to the understanding or interpretation of the norms of law governing the exercise of the power or faculty. Error of fact arises from the erroneous assessment of factual circumstances, and therefore they think that the particular individual or priest have the power in accordance with the juridical norms. Here the error must be based on a solid and constant public fact, that is, capable of causing error. Doubt is a situation pertaining to the individual or priest who exercises the power or faculty. Doubt is said to be positive and probable, when this individual, despite his doubt, has good reasons to believe that he has the power and that, if he exercises it, he will very probably do it according to the ordinary always required. Consequently, it is not enough to base the doubt on negative reasons, such as the negligence or failure from the part of the person performing the act. Doubt of law means arising from an assessment of law, and doubt of fact means arising from law's applicability to the fact or case in question. Thanks for watching. Kindly subscribe to my YouTube channel Canon Law Explained for more videos on marriage.